Thank you, Chairman. Judge Jackson, you can relax for a bit. I voted for you for the D.C. Circuit, and when you appeared as a potential nominee, we started doing work looking at your record and your story. We met with the president to discuss his process and his goals. When your nomination was announced, we obviously brought the work on your record more into focus, and now I've had the chance over, 15, 16 hours to see your performance in this hearing, which I think sets the gold standard for patience and courtesy. So I'm prepared to not only support you, but to let you know that I will be very proud and very honored and very excited to support you. There are two things that have come up during the course of the hearing, Mr. Chairman, that I'd like to take my time to have a chance to respond to. And the first has been a question, I've been through a bunch of these now. I don't think I've ever heard it come up so much. Questions about the nominee's judicial philosophy. I didn't know you needed to have one. I actually thought that when you're dealing with the Constitution, your oath of office, the constitutional precedents, and the Constitution itself kind of gave you your guide path. And when you're construing statutes, the law and the conventions of the language and your logic gave you that path. So the fact that Judge Jackson has said, I don't have a judicial philosophy, I've got a judicial methodology, doesn't bother me a bit. In fact, it kind of bothers me the expectation that a nominee to the Supreme Court should have a judicial philosophy. Because a judicial philosophy can be a screen for a predisposition that judges, frankly, should not have, but that folks and powers and interests influential in the process may very well want them to have. So, when I think about judicial philosophy, one of them that's come up a lot has been originalism, and one of the problems with the judicial philosophy is occasional adherence, selective adherence, which in my mind makes it less of a judicial philosophy and more of a doctrine of convenience to be trotted out when it helps the people that you want to help. And originalism strikes me as being that kind of a doctrine. And the place where I think we have the biggest gap between philosophy and practice in all of this has been with respect to what I've witnessed with respect to corporate power in our democracy in the time that I have been in the Senate. If you go back to the founding days, there was no expectation that corporations would have any role in American democracy. Nil. Doesn't turn up in the constitutional debates, doesn't turn up in the arguments leading up to the approval of the Constitution. It's only when corporations became big and powerful many decades later that they began to intrude in our politics, and they corrupted our politics in a terrible way, history shows. And that led to the movement by muckrakers, whose probably best leader was Teddy Roosevelt, to knock down the grasping political power of corporations and rein them in. And we had some real victories at that time, but ambitions of those of great wealth and power do not go away, and they have continually crept forward. It's an age-old story. And right now, we have corporate power controlling this Congress in a way that is really remarkable. We have a complete inability to address the climate havoc that fossil fuel emissions are creating because half of Congress has been disarmed and disabled by political influence of the fossil fuel industry. We can't even have a reasonable and sensible discussion on it. because the power of that industry is so great. And we've seen that manifested first with Republican justices on the Supreme Court letting corporations into politics. That was an interesting invention. And then once they were in, they let them spend money in politics. And then once they let them spend money in politics, they let them spend unlimited money in politics. And now we are looking at a court whose majority is in the process of building a right for corporations, the biggest and most powerful corporations that we have, to not only get into politics, spend money in politics, and spend unlimited money in politics, but to spend unlimited money in politics anonymously, to hide from the real voters, the we the people, who they actually are when they're intervening in our politics, and to play this game through phony front groups with ridiculous names. Rhode Islanders for peace and puppies and prosperity, you know, sort of the quality of the name that's involved. So let's not get too excited about judicial philosophy if it's nothing more than a screen for a predisposition that will benefit certain players in the arena. And let's certainly not take judicial philosophy too seriously when it evaporates in the face of the interests that have pushed the philosophy. And I think originalism qualifies that way, and I just wanted to say that. I don't think you have to have a judicial philosophy. I think you have to have integrity. I think you have to have a judicial temperament. But a philosophy? Where has that come from? The second thing I want to say has to do with the question of court packing and the integrity of the court. And I have a position on this, and I just want to say it so it's all clear and nobody's reading things into it that I don't believe, and I've had a chance to make my point here. And that is that court packing can be done by adding new seats to the court. I haven't proposed that. I think there's only one member in the Senate that has proposed that. It's gotten a lot of attention here, but I don't think it's been proposed here. But you can also pack a court by picking the justices. And in fact, there is a long, unpleasant American tradition of agencies being taken over by virtue of picking the members. It's called agency capture or regulatory capture. It goes back a long way. There is an abundant literature, both in economics and in administrative law, about capture. And there's nothing that makes a court immune to capture. That is why when I talked about this in my initial remarks, I said that the folks that have tried to capture the court have treated it no different than a 19th century railroad commission, because they were legendary for having been captured by picking the members who would rule for the railroad. And there are many others. Go back to MMS in the Gulf oil explosion. So that is my concern. My concern is that the picking of the justices has been handed to special interests. And we know that's the case because, as I showed yesterday, everybody involved admitted it. The President of the United States said so. The co-founder of the Federalist Society said so. A former chairman of this committee said so. And the President's legal counsel said so. And what happened in that process by which the justices were picked over at the Federalist Society? We don't know. There wasn't a poll that was taken of Federalist Society members saying, you know, give us your recommendations. I don't know that there was any meeting of the board. Let's take this up. Let's go through a proper agenda. What appears to have happened is that people went into a back room and there was wheeling and dealing, and millions of dark money dollars flowed into the Federalist Society during this period. And what came out were names. And those went straight to the president and straight to here. But the picking appears to have been done in the confines of a private organization by anonymous special interests. There is no country in the world that does that by way of how you pick judges. If we went to some banana republic to try to educate them in democracy, and that was the way they picked their judges, we'd have a lot to say about it. But that is the way that recent justices have been picked. Court packing by court picking. And deputizing this to the Federalist Society is very unusual. Them having no process, no public process for implementing that deputization is very unusual. The provenance of these mysterious lists that were produced and how people got on and off them, that is very unusual, unprecedented in our history. And it's surrounded by lots and lots of dark money. $400 million, I think, is a lot of anonymous money that has been chronicled being spent to control who gets put on the court. And controlling who gets put on a governmental body is how you capture a governmental body, and a captured governmental body is a wrong thing, whether it's a railroad commission or the United States Supreme Court. There is in that method of judicial selection not just the prospect of impropriety, but indeed the likelihood of impropriety. If it's pay to play and checks for millions anonymously delivered will get you into the room to decide who is going to be on the Supreme Court, we got a problem. And that's what happened. And the thing that makes it even worse, in my view, is that as you pursue this and play it out, you see the decisions of the court line up in an astonishingly clear pattern with the interests of big Republican dark money donors. That is my concern. That, I think, is a legitimate concern. If you disagree with me, disagree with me. But that is the concern, and I wanted to lay it out here because it's not about court packing. It's about the integrity of the court, and it's about the unfortunate comparison that can be made now between the captured agencies delivered through picking of their membership and what looks more and more like a captured court delivered by the picking of its membership in secret with a very, very high ticket price to be in the room where the picking took place. So, like I said, colleagues can agree, colleagues can disagree with, we all have our shots to make our cases. Because this has come up tangentially in multiple different ways, I wanted to take this moment and lay out what my case is and explain it as clearly and simply as I can. And I thank the chairman for allowing me that opportunity. And I yield back my remaining 7 minutes. And I congratulate, Your Honor, you for the patience that you've shown with all of us. It's not over, but it's close.
Thank you, Senator.